I don't know if that answered your question, but there is there is a process, and when it's
No,
not fair, it can be quick. It can be.
well, right. Well, that was going to be my next question because I feel like there's a lot of procedures in California, not just California, and a lot of states that are not very quick. So,
Mhm.
and we don't always have that information as practitioners guiding our clients early on to petition these states to say, wait. We need to do this, or we'd like to do this. And so it's important, though, I think for the listeners to understand that these rules do exist, but there's a process about how to apply them. And it's not just you can take a position on a return and the states are going to let it sail through.
No, and in fact, California has a policy. It's in a, I think it's a notice, but you cannot take an alternative apportionment position on an original return. You need to file a petition. So you need to go, if you think it's unfair in 25-137, the alternative apportionment statute should apply. You file the return under the rules that are not fair, then you file, I would file a claim for refund for one, just to make sure wasn't losing anything, but then say we want alternative apportionment and here's why.
Right.
And if you have a good case, great. If not, you can take it up. But, most of these cases that are close end up settling. So if you have something, it's, you measure the value of it and the time and expense and how much we're talking about. It's usually when there's a big sale, a big slug of income.
Yep. It's all good.
As we've kind of been talking about apportionment, we'd love to kind of hear, California has their legal ruling, the 2201 on kind of the sales of services stuff.
Mm-hmm.
What are
Stuff.
Yes.
Technical term. Right? A technical term. Stuff.
That is yes. It depends and stuff. That is the language of a state tax professional. How are you feeling about that?
I understand why you said stuff, because it's very hard to articulate exactly what was going on and what they're doing. You have to do a lot of reading between the lines to see what they're trying to do. So taking just a step back and looking at what they did and what they moved away from, they are pushing more the look-through concept of looking to the customer's customer. But they don't say it all that plainly. They are bound by a statute, and the statute looks to, the statute says purchaser. The regulation is just called purchaser customer for some reason. I wish they would change that. Nevertheless, they say customer's customer. And that's what this most recent legal ruling is kind of retracting a chief counsel ruling that earlier in 2017, and there was one in 2015 also, that applied the rules for intangibles, and the rules for intangibles in the regulations break out intangibles into marketing and non-marketing intangibles. So marketing intangible would be like Jeffrey's giraffe trademark kind of stuff. Non-marketing intangible would be like a patent for manufacturing. And in the rules for the distinction is in the marketing intangible, they look through to the ultimate customer. So they won't just look at the Jeffrey store. They'll look to where's the market for sales. But with non-marketing intangibles, they look to the immediate customer, purchaser. So this legal ruling, and it started with 2015-3. And so I'm going to talk about 2015-3 and 2017-1 first before I get into 2022-1, because you kind of need to know what they were doing first and what are they doing now to correct what they don't like anymore. So 2015-3 is where this whole notion of analogizing the marketing and non-marketing intangible to services. So FTD looked at this situation, and the situation involved a company that sort of aggregated data for financial companies, for investment advisors and whatnot, and was all online. And they sold it to the investment advisors, who then used that for their clients, and their clients use this stuff also. And so FTB came out and they said, all right, we don't look to for services, we don't do the look through rule. We look to the customer. This is all going to be really confusing and not make a lot of sense. I'm trying to explain what they did. It's not me. So they say, okay, well, that's what the statute says, but to reasonably approximate how these sales revenue was sourced, we're going to look to this CPU usage that the client maintained, which was the customer's activity. So the more activity they had, the more the cost was. So they said, okay, we look to our client, the investment advisors, we look to them, but how do we figure out where they got the benefit? Well, we're going to look to this CPU data is fair to look at that. So that's how they ended that. And looking back now to what 2022-1 says, so it seems like the answer is going to be the same. But I think it's the rationale, this whole notion of the non-marketing and marketing sales, they're going to do away with it. They have done away with it without saying as much. 2017-1, this one's kind of like, really, I kind of think this is what they really did not like. And it's kind of similar, Meredith, to the situation you brought up with the insurance companies. So this is a healthcare provider. So you have a healthcare plans, they've got their subscribers who get prescriptions and whatnot. And so they contract with a company that is going to fulfill all the prescriptions. So the question was, okay, so where does this revenue get sourced to when we're providing this service to the medical plans, and we're delivering the medications to the ultimate users? And so they looked and they said, okay, we're going to do marketing versus non-marketing again. Now this service we think they concluded it was a non-marketing service. It wasn't marketing, it was fulfilling something. So then they said, all right, well, following that, we just look to the customer. We don't look to the customer's customer. So what they concluded was, so this should be sourced to where the direct customer would have had to perform this had they not engaged you at all. So they concluded, well, that would be at your office. That would be at the office of the healthcare companies, not where all of the patients are or the subscribers who are taking the medications are. So those are the two chief counsel rulings, which now we get into the legal ruling 2022-1, and it goes through three different scenarios. Scenario 1 and scenario 3, nothing's changed and they were pretty obvious. But scenario 2 is exactly 2017-1, the exact scenario. And they came out the other way. They said, in this case, they didn't even mention this marketing and non-marketing service at all, not a word of it. And they said, look to, and they kind of refocused how we're figuring out where the benefit of the service was received. Before, they were really focused on where. Where is it? Where is it? Where is it? But in this new legal ruling, what they've done is they said, we're not going to look at where, we're going to look at what is it? What is the benefit? And by defining the benefit as giving your customers their drugs, they kind of answer the question of where it is. So that's how they defined it in the legal ruling. Where are you getting your drugs? That's where the subscribers are. So that's where this revenue should be sourced. And then at the end, they say, Chief Counsel Ruling 2015-3 and Chief Counsel Ruling 2017-1 are revoked. They don't explain why. They just say they're revoked. But this is my 2 cents worth as far as what all this means.
So, Michael, we really appreciate your insight and your knowledge, and getting a chance to talk to you. And just kind of as we wrap up, don't want to pigeonhole you, and you are a multi-state tax, expert, What is one of your most interesting or favorite non-California positions or cases that you've kind of gotten to play around with?
Non-California, let me think about this. There's a lot of ways to answer this. I'm always careful when I give the questions. We'll get back to 30 days.
We do caveat, we do, this is not live. We can always edit, and we do caveat that we are not providing tax advice during these tapings.
So, like, are you thinking about a specific state, or more like the Vast Holdings case and investee apportionment is really interesting. It really kind of doesn't really matter what state you're in. Now, I know Vast Holdings, the Supreme Court in Massachusetts said, hey, it's not authorized by statute. Get out of here. You can't do it. Mm-hmm. But I wonder what will happen with the legislature. Maybe they will say this is fine. And then is it okay? They said it was constitutionally. And then we've got this Goldman Sachs case out of New York City, which is really doing the same thing. They said it was fine constitutionally to tax based on investee apportionment. Something that, like, the things I get interested in is, where is this going from here? And it takes a long time for things to develop in the state and local tax worlds to where this is going. Like, investee apportionment, that creates nexus. Like, the states rely on this international harvester case and J.C. Penney's case, and you see the Supreme Court cases from the 40s to say, hey, due process, no problem. But that's a long time ago, and due process has a lot since then. I mean, international shoe is the case everyone talks about in minimum contacts, international shoe. And we look at what the Supreme Court has done recently, like in the Kimberly Rice Trust case, in Wayfair. There's Wayfair referring to Quill. There's a separate due process requirement as well as Commerce Clause. So is it enough, or do we have to look at the contacts of the taxpayer, or is it just enough that it's sourced to the state? Is that enough? Like, and really, like, what the states will say to get jurisdiction is, all right, international harvester, has the state given anything for which it can ask in return? It's such a vague concept, and 6 degrees of separation, at some point you're going to maybe find something there, but is that enough under current jurisprudence under the due process clause to allow states to do that? Like, we talk about Wayfair, but Wayfair's Commerce Clause case doesn't even talk about due process. So the fact that taxpayers thought they had this sort of protection under the Commerce Clause via Quill, that's gone now, but that was kind of like where all of the action would have been. That, hey, we're protected, we got Quill, we're good. We don't even need to talk about due process, we're fine. Well, now that's gone. So I think due process is going to have a revival. We're going to see more due process cases. And that's not just Wayfair, that's not just sales tax, sales and use tax collection obligations, but the states look at Wayfair and say, if for those states that don't already have a factor presence or economic nexus, hey, we can do it now. We got Wayfair, we'll rely on that, despite the fact that it's just a Commerce Clause case and a use tax case. And then what about the localities, like the San Francisco and localities throughout the country? Economic nexus there, why can't they do it then? And you look at
Philly come out with something last year, 2 years ago.
Yeah. San Francisco also, they've got a $500,000 threshold. So there's going to be, and for those folks who are making all their money online, I mean, SaaS is the obvious one, but technology is moving so fast, and like, what's not done online now? There's going to be some challenges for them to figure out how to comply, or when to, because a lot of these cases come about because they didn't know. Like, I don't know of very many taxpayers who are like, let's just plan for litigation. They just like, oh, well, you're saying we have to do this? That doesn't seem right, but we'll just do it anyway because we don't want to spend our time on taxes. We don't like state and local tax like you do, Mike. Okay. So there's going to be a lot of sort of surprise assessments because of this, and then retroactivity, that's still up in the air as well.
Yeah,
There's a lot of arguments to be made.
Activity for your state, and I know that we're, coming to a conclusion here shortly here, but I did want to just kind of pick your brain. Some things that we've seen recently for some of our pure remote sellers, they went ahead and they registered, started collecting, started remitting in the state of California based on that magical April 1, 2019 date. And now they're starting to get notices from the FTB saying, hey, where's your income tax returns?
Mm-hmm.
That seems to be a very common theme recently.
Oh yeah, they share.
Clearly they're matching up records, but I guess I go back to kind of that nexus discussion that we had early on about the magical number for, and again, this is where maybe we shouldn't hang our hat so much on the numbers, but the Wayfair threshold being 500, but the income tax threshold being something more than that. And our taxpayer is going to challenge that to say, hey, that wasn't the threshold in 2019. I don't know. Do any of those arguments even have legs, right?
Well, yeah, I mean, to me, they're two separate regimes.
Yep.
So, hey, if you got nexus under one but not another, you don't file in California if you don't have income tax nexus. Like, let's just say you got 600,000. You thread the needle where you don't have to do income tax. Well, that's right. I don't know if FTB is going to say you have. I don't think FTB is going to say you have anyway. They have this statute, and they've also come out. There was a legal ruling. Geez, probably 6 or 7 years ago about throwback, and basically they said the legislature came up with this, and this is sort of constitutionally the limit. So you need to hit this limit, or you have to throw back in California. But they change their mind depending on the facts in the case.
Right. It's all there.
Yeah. You got to, you could be subject to use tax collection and registration with the CDTFA for sales tax, but not subject to the income franchise tax. It's possible.
Yep.
Well, or could you claim 86,272, but under what condition of reinterpretation, modernization that's always been there, or traditional, like non-modernized?
Yeah, the unmodern, the old rusty.
Right, the 1959 version, right?
And maybe it needs a tune-up. It's possible it needs a tune-up, but it is federal legislation.
Correct.
It's kind of, the law is what the law is. State's arguments are, we're just interpreting facts. The law is what the law is. And the big question is, are you activity in a state based solely on your customers going online and looking at stuff? Seems like a slippery slope. Like if I say facts, that's no. If I call you, no. But if I click on the website, that's yes all of a sudden. And then I wonder about the Internet Tax Freedom Act non-discrimination provisions. So, man, you are definitely picking on, this is the only way we're chatting is via the internet. And those people are using stamps or fax machine. We're not. But, their argument is eventually stamps and fax machines just don't exist anymore. And it's all interconnected. And if you use the internet, then you have nexus everywhere. Seems to defeat the purpose of the Commerce Clause and the Internet Tax Freedom Act. And it just doesn't seem right. Like, I'm sitting here in my office and I'm on the internet, and I'm just creating nexus everywhere. Like, what about and here's the other thing. I have to wrap up. You guys can just say, be quiet. But literally, I told Stacy this when we did a webinar together years ago, that I could talk nonstop about salt. Like, give me a week. I could just keep talking. There's so much to talk about. So we talked about the market-based sourcing. We talked about how market-based sourcing can create sales, which create nexus. Now you're looking at these market-based sourcing rules, which are iffy, vague, you're unsure, but those are going to ultimately create nexus for you. And now look at the jurisprudence of the due process jurisprudence of what creates nexus. It's like, man, you know what? I'm here in India, and I have a client in Japan that I do some stuff for remotely. And this Japanese company has customers in California. Do I have due process nexus in California because of that? Well, I don't know. That's one that's ripe for litigation for sure.
No, and probably not just in California.
No. These issues are states. Every state.
That's why the conversation's never ending. You
That's
get
right.
through all 50 of them, and then the first one that you started is back, change what they did by the time you got done talking about all the other ones.
Yeah, no doubt. But the Constitution applies to all the states. So these constitutional arguments apply to all.
No.
Yep. Well, Michael, we really appreciate your time and certainly kind of your insight. And it was a good reminder to think about what's next when these kind of decisions come out, these rulings come out, because oftentimes as tax practitioners, we're working in arrears, right? We're fixing the past, we're arguing the past. The current tax return we're working on is for last year. So it is a nice reminder to be thinking about what's next and getting away from that next, or, that historical. So
yeah, I'm even further back. I'm working 5 to 10 years.
yeah.
But always keeping track of the current too, but audits, they go
Right.
and
Oh, yeah.
Another thing we should mention, if we're talking about California, it would be, we got to mention the regulations, and they're the 25-136-2 market-based sourcing regulations in California, originally adopted in 2011, modified a couple of years later, and since it started, there's been an open regulation project, and there still is one now. They have proposed regulations that they went to the board to ask if they could go to final. Can we go through the process to finalize these? Now, to do that, they have to issue a notice and then have hearings and be all final. They have interested parties meetings, which are all just drafts stuff, conversation. But to actually get regulations final, they have to go through all of this process, and they have to ask the board permission to do that. And they did that in December. So now they have the green light. And during the hearing, they said, yeah, a couple little things, but we're ready to go. Then out of the blue, we get the legal ruling 2022-1, and it's like, wow, where is this? So perhaps because they haven't done anything yet as far as the formal notice, perhaps they're retinkering with it. But for anyone interested in their California liability, you really got to follow what's going on with these regs, because there's some pretty big changes, which we could talk about for another 2 hours. Honestly, there's so many.
Well, we'll meet in Nevada next time and talk about these over something a little stronger, than water.
Absolutely.
Meet halfway in a non-income tax state.
There you go.
I won't bring my phone because maybe that will get California.
I don't know. Where am I?
Yeah,
I have
exactly.
I have a non-Colorado zip code or area code. So where am I?
Right, exactly.
Oh yeah. VoIP. What are those commercials where you can get a VPN and wherever you want? That's where you are.
Yep. I'm just
Yep.
going to start operating off burner phones.
There
Use
you
them,
go.
throw them out like I'm a crook.
That's not suspicious or anything. No.
I can't get away with that. They all know where I am. They know where I am. I can't get away. So
Well, I was gonna say you're in Hotel California. What are you talking about?
Yes. Yep. That's a whole nother hour conversation about how do you leave.
Exactly.
Well, thank you, everyone.
Yep.
This has been
Absolutely,
another
absolutely.
episode of Saltivation. Until next time.